Good afternoon and welcome to our penultimate session with the Tribal Justice Seminar Series. This is a series presented by the University of California, Davis Law School, the Oki Center. And they would like to acknowledge that they sit on the land of the Patwin tribes and acknowledge a responsibility to conduct themselves accordingly. Those of you who are able to join us today are in for a very special treat. I was teasing Chad Smith, the director of this series, earlier today about the fact that, like any good host, he saved the two best for last. Today, we have a very special treat. And to acknowledge, I am a member of her fan club. There are not many people who I would fight for the right to join their fan club. But you're going to hear from two of them this week and next week. I have served as a judge for 34 years for 30 different tribes in a dozen different states. And I've served as a trial judge for the state of Utah for 14 years, and the State Court of Appeals for 13 years. I'm Pomo Coast Miwok, and I'm enrolled at Grayton. And over those 40 some years of being a judge, there are a handful of people who stand out, who just shine a light and make everyone around them better because of who they are and what they bring to the table and the heart that they add to any equation. Judge Williams is one of those people. I used to be able to get away with saying that she was a youngster. She's not old by any means, but she's crossed the 20-year mark in terms of experience. She graduated from law school in 2020 from Arizona State University, and she has been a judge now for 10 years. Let me run through some of the qualifications. She's a Yurok tribal member. She currently serves as chief judge of the Wilton Tribal Court. She's the chairperson of the California Tribal Judges Association. She's on the California Judicial Council's Tribal Court State Court Forum. She's a member of the California Indian Law Association and the National American Indian Court Judges Association. So those are her legal credentials. But Christine is one of those rare people that I found who can take everything she learned in law school and not be bound by that. To be able to ask the question, what's fair? What might work better? She's one of those few people who I think truly is a leader. And we have the honor of welcoming her today. Christine said that she would like to have questions saved for the end, but I promised her that I would interrupt at some point just to try and keep her on her toes. But one of my favorite people, Judge Christine Williams. Christine, take it over.
Well, thank you, Judge Thorne. I'm thoroughly embarrassed now and humbled. And I think you are not only the only member of my fan club, but probably the president, secretary, and treasurer. So we will be looking for a financial report later. Anyway, moving on. Welcome, everybody. Thank you so much for having me. I want to thank Chad Smith and Judge Thorne, and I know John Miller's hiding behind a basket right now, and for hosting this seminar series and for inviting me to be part of it. I really appreciate it. And I am going to attempt now to share my screen with you and jump right in, because when it comes to talking about tribal courts and Public Law 280, I have so much to say. So, see if I can do this. All right, hopefully everyone can see the PowerPoint. Okay, someone give me a thumbs down if you can't. Okay, so my focus is going to be talking about Public Law 280 and tribal court jurisdiction. And, you know, in less than an hour, I'm not going to be able to cover everything, but I did want to get a nice introduction for everyone. And then, you know, if there's a lot of comments and questions, we can certainly go past the hour, and I'm free to stay on and try to answer those as we go. So getting right into it, pop quiz. Woo! There are approximately, and this number is dynamic, but 574 tribes in America. How many are Public Law 280? And so I'm going to ask John, and I'm going to ask Judge Thorne to look in the chat, throw some numbers into the chat, everyone. Tell me what you think. We're going to just take a second here. How many of these tribes do you think, approximately, are from Public Law 280 states? Tribes within states that have Public Law 280 jurisdiction.
There's a guess for 500,
Okay.
300, 74,
Okay.
10,
Excellent.
250, 375, 1/3, 280.
Awesome. 280. Oh, that's fun. That would be a fun number just because it's Public Law 280. But okay, so guessing we'll stop. We'll go next. Oops. The majority under the total here are in partial or complete Public Law 280 jurisdiction. And just in Alaska and California alone, there are over 330 tribes, and those two states are both Public Law 280. So just wanted to start with a little background, little context, because there's a lot of perceptions about Public Law 280, and those a lot of times I think tribes in Public Law 280 states get dismissed as being non-dominant or the alternative system. And that attitude really takes us, oh, I don't know why that happened. That really takes us to being dismissed sometimes in terms of funding, in terms of being taken seriously as a court. So just wanted to dispel some myths. I remember in law school when I was taking Federal Indian Law 1 and 2 and all the variations that I was privileged to have access to. A lot of times we get to something about Public Law 280 and whoever was speaking would just say, I don't really know much about this, so we're just going to skip it. So we're not going to skip it today. That is going to be the focus. So I'm going to start with a little background, little, on what is Public Law 280 and how is it different from tribes that are in non-Public Law 280 states. So with that, I want to always start with a discussion about inherent sovereignty. I think it's critical to everything we're going to talk about for the rest of our time together. So pre-contact, time immemorial, before we had the influence of outsiders, we have inherent sovereignty. And sovereignty and jurisdiction and all of those sort of retained power dynamics we talk about, they're not given to tribes. Slowly, our sovereignty as tribes was eroded over time by federal and state intervention. But I always like to start with that to remind everyone, this is, our inherent sovereignty it's retained and not a gift. It's something that comes from within. Okay, limits on tribal jurisdiction. So Congress passed laws limiting tribal jurisdiction, and the three main ones are the Indian Country Crimes Act, which is also called the General Crimes Act, the Major Crimes Act, and Public Law 280, aka PL 280. The first two address criminal jurisdiction, and then Public Law 280 talks about criminal and also civil jurisdiction. So let's get into those. Oh, just want to also add, all of these limitations are paternalistic at best, and honestly, probably more likely racist. And we'll talk about why. So Indian Country Crimes Act, quickly going to blow through this, but basically it was extended to be a buffer between tribal people and non-native people, because back in 1790, there was a lot of conflict that was erupting on tribal lands. So after several revisions, it's now the Indian Country Crimes Act or the General Crimes Act, and it extends federal jurisdiction over crimes in Indian country involving a non-Indian and an Indian. And that jurisdiction is concurrent with tribes. So basically non-Indian crime goes to the state, Indian tribal jurisdiction exclusively when this was passed. Okay, moving on. Just going to add a little California history note. I'm going to try to keep this generally about Public Law 280 tribes across multiple states, but I am Yurok. I do have to throw in the California history note because I think it's interesting again about what is said is behind a law and what might be the reality behind an actual law being passed. And there's me throwing out law school, like Judge Thorne said. So California became a state in 1850, and that's after the Indian Country Crimes Act. And in 1851 to 1852, the 18 treaties, which if you're from a California tribe, you've heard of these 18 treaties, created a lot of landless Indians because the treaties were not ratified. And basically the feds were not acting as a buffer in California at all at that time. California was actually legislating to exterminate the Indian population without any federal intervention of any kind. So I just want to throw that out there, that we have the stated reason for why that law was passed, and then we have the history, at least from the perspective of my people and my family, of what was happening in our communities. So, Major Crimes Act, probably one of my least favorite acts. I don't like it. In 1885, Congress divested all tribes of jurisdiction over major crimes, and basically gifted that right over to the federal government. So it does not depend on the identity like the Indian Country Crimes Act. It just depends on the type of crimes, and it applied to major crimes, which I'm going to just sort of break down in a simple way as basically felonies. That's what we would call felonies now. And again, this is a generalization, but we don't have 3 years, which is how long it took me to learn a lot of this. So non-major crimes, not involving a non-Indian. So if it's an Indian crime, at this point, still under the tribal jurisdiction. Then we have Public Law 280. In 1953, so in my mind, that is relatively recently, but in 1953, Congress transferred the jurisdiction that had been granted to the federal government by the Indian Country Crimes Act and the Major Crimes Act in certain mandatory states to the state government. Tribes were not consulted on this, and it also granted some civil jurisdiction to those states. So it was not only taking that federal jurisdiction that was already there and in place, but also expanding that a little and then giving it on over to the states. So here's the mandatory states that were initially identified in Public Law 280, just to give you a sense of, where it started. In 1968, there was an amendment. The state and tribes were very critical of Public Law 280 from the beginning. So the act was amended, requiring any states to that were going to be voluntarily opting into this jurisdiction to obtain tribal consent. And so, probably doesn't surprise you, there hasn't been a lot of expansion of that jurisdiction since then. And then this amendment also provided an avenue for retrocession. And retrocession does not mean tribes regain their full jurisdiction they had. It means they go back to the federal system under the Major Crimes Act and General Crimes Act. So that's my summary of Public Law 280 in a nutshell. What I really want to talk about, though, is, so what do tribal courts have in terms of jurisdiction today that are in Public Law 280 states? And the reason I love talking about this is because as a tribal court judge in a Public Law 280 state, there's a lot that can be done, and I think it's really important. So currently, right now, in 2021, I want to be clear, tribes still do not have complete jurisdiction within their own boundaries. And I do want to be clear about that, because those laws that we talked about, they're old. They haven't been updated. They're still in place. I think there's still a belief that tribal courts are not fit to exercise complete jurisdiction over non-Indians. And I think there's a belief that tribal courts are not fit to exercise complete jurisdiction over all types of crime, even when it's their own members who are involved. And that's why I said it before, that it's paternalistic at best and racist more likely. So, jurisdiction. Jurisdiction is the authority over people and things. And I want to talk about who has what authority over which people and how that relates to tribal courts in California and in other Public Law 280 states. And then also how that's determined from case to case. So let's start with state jurisdiction under Public Law 280. So the state has criminal jurisdiction over crimes in Indian country to the same extent the state has jurisdiction anywhere else in the state when you're in a Public Law 280 state. So it just essentially removed that reservation boundary for purposes of state criminal jurisdiction. So things I learned about in law school about hot pursuit and different things that apply in non-public law 280 states, they don't apply here. It revoked the Major Crimes Act and the Indian Country Crimes Act in the mandatory states. And it also extended state civil jurisdiction and laws of general application into tribal Indian country in those states. So what are the limits though on state jurisdiction? When can the state exercise jurisdiction? So the general test, and I think this was really popularized by Carol Goldberg, is that if it's criminal prohibitory, then yes, the state does have jurisdiction, versus if it's civil regulatory, then no, the state does not have jurisdiction. So again, very general test, but when you're talking about a certain case or a certain matter or type of law, you can ask yourself the public law 280 test. And again, this is a very simplified version of whether or not the state's going to have jurisdiction, but it is a really helpful starting place, and it often leads you to the right answer. So here are absolutes. State cannot exercise jurisdiction over regulation, over the ownership, possession, or disposition of trust lands, the hunting and fishing guaranteed by treaty, statute, or other federal mandate, taxation, and there's like an asterisk on taxation, it gets real complicated, but basically the states can't tax tribes generally. And then one of my favorites, wholly internal tribal matters, and the two examples I give here are enrollment and elections. So the states can't intervene on these matters. So let's talk about tribal jurisdiction concurrent. Generally, tribes in public law 280 states do not have exclusive criminal or juvenile jurisdiction. Generally, tribes have concurrent jurisdiction over Indians in criminal, sorry, I can't see the whole part, but criminal and civil matters arising in Indian country. So recent federal law expanded criminal jurisdiction over non-Indians in specific circumstances. And so you're going to want to look at the Tribal Law and Order Act for more information on that. We do not have time to cover it, although I'd love to. It's fascinating. And tribes can exercise civil jurisdiction over non-Indians when there's a relationship to the jurisdiction. Tribes have concurrent jurisdiction in all juvenile matters involving their Indian children, both on and off the reservation. It may require a transfer to tribal court. So that's the breakdown of the concurrent jurisdiction. And I love concurrent jurisdiction. I think one of the things I've known for is helping to start a joint jurisdiction court for a tribe in California, because it really occurred to me, what does concurrent jurisdiction mean? How do two jurisdictions exercise the same jurisdiction concurrently? Found a way to do that. You sit on the bench with the state court judge at the tribal court and hear cases together. And it's not as easy as, just snapping your fingers, but I've had some really good outcomes for tribal families, and I think it's been worthwhile. So dive into that concurrent jurisdiction. Try to define for yourselves what it means. All right, resumptions of tribal jurisdiction, Violence Against Women Act. So the Violence Against Women Act, also known as VAWA, reauthorization of 2013, authorized special domestic violence criminal jurisdiction. Breaking it down, tribes can prosecute non-Indians who have a connection to the tribe and who commit domestic violence or dating violence, or who violate a protection order against an Indian person. The exception is if the victim and defendant are both non-Indians. So this was a huge advance for protecting Native families and Native women, and also regaining some of that inherent sovereignty that tribes lost under federal jurisdiction. So there's conditions, and a lot of them basically boil down to, for a tribe to exercise this special criminal jurisdiction, they need to look a lot like a state court. So providing the defendant with the rights under the Indian Civil Rights Act, defense counsel, trial by jury, and other required constitutional rights. So it's not perfect. I think it's a huge advance. However, a lot of tribes, at least in California, are not exercising any kind of criminal jurisdiction. So I haven't seen this in practical use a lot yet, but I'm still supportive that it's there. Okay, retain jurisdiction. So this is what we really came to talk about today, or at least what I came to talk about. And I get to decide because it's my PowerPoint. So jurisdiction you exercise is powerful. And I wanted to start with this image because it shows how nature and the ocean is powerful. And I want to really focus on the power of exercising tribal court jurisdiction in public law 280 states and my ideas around how we can make that count. So send a message. Laws are a social contract that proclaim the values of a community. When you enact and enforce laws, it sends a message about what you expect from people and how you will respond to those who violate those expectations. Will you respond punitively? Will you respond restoratively? And I think that in these times, I'm going to get up on my little tiny soapbox now, but in these times of civil unrest, we could all really benefit from positive messages and models. So keep that in mind. I feel like growing up as a tribal member in California, which is a public law 280 state, there was a lot of just feeling invisible, the invisible minority. And even when you look at attaining funding or supporting legislation, the first thing people want to go to is just raw numbers and data. And it was a constant message to me that because our numbers were not as large as other tribes, that we didn't really matter. And I'm here to tell you that you do matter and that, like I said, models and messages come from a lot of different places and they're all significant. So keep going, keep on this road with me because I can't do all this alone. So what tribal jurisdiction is left? A lot, tons, a lot. Okay, we don't have exclusive criminal jurisdiction. So what? We still have jurisdiction over criminal violations, peace and protection, law and order ordinances, family law. Who doesn't have a family law issue from at one point or another in their life? Civil disputes, housing and land use, juvenile, Indian child welfare, domestic violence, natural and cultural resources, and of course, internal tribal governance. And then, of course, whatever laws the tribe can create and enforce. It's time to get creative. I want to see what people can do out there. All right, peace and protection. I'm going to run through these laws, and I know I'm speaking out of clip, but I do want to get to questions, so I'm going to power through. So peace and protection, law and order. This is about keeping the peace and quality of life on the reservation. Oh, and I do want to acknowledge, and I understand in Alaska, reservation is complex. Land is complex, and not all tribes in public law 280 states have land that could be considered a reservation. Doesn't mean you can't do things. In fact, some of the most innovating practices I see right now are coming out of tribes in Alaska who are essentially, to oversimplify, landless. So no excuses, only progress. Civil or criminal? Tribes in public law 280 states have criminal jurisdiction over Indians. It is concurrent, it is not exclusive, and you don't have criminal jurisdiction over the major crimes because, again, we're seen as unfit. But civil jurisdiction over non-Indians. So we don't have criminal jurisdiction generally, unless it's a special exception, over non-Indians. So here I want to ask, and maybe I shouldn't, but does the test to determine if states can exercise jurisdiction apply to tribal courts and tribal law enforcement? And hopefully everyone remembers that test, criminal prohibitory versus civil regulatory. And I'm just going to leave you with that. That's a discussion question for your mind, but something to think about. So basically, if you call all of your infractions civil, then do you have the authority to exercise jurisdiction over everyone within your territory? I say yes. All right, tribal family law, marriages, divorces, custody disputes, adoptions. Really quick note on the Indian Child Welfare Act. The Indian Child Welfare Act is a federal law passed to establish minimum standards to apply to state court, and that's in bold. It's like I'm yelling at you, kind of I am, because this is intended to counteract institutional bias, longstanding, that was aimed at destroying Native communities and families, and that bias remains in state court proceedings. It doesn't apply in tribal court. So I think it's just one of the like nerdy pet peeves of mine when people call a case an ICWA case in tribal court. It's a child welfare case, maybe it might be an Indian child case, but it can't be an ICWA case because those are specifically in state court and they're designed to counteract bias. So next, domestic relations. Marriage, people can wed under tribal law. Divorce, people can unwed under tribal law. Child custody and support. Tribes can issue orders regarding visitation, custody, and support under tribal law in Public Law 280 states. Marriage and domestic partnerships. Concurrent jurisdiction between tribes and states. So if you're married under the state law, then the tribe will recognize you as married unless the marriage violates tribal laws. If you're married under tribal law, the state will recognize you as married unless it violates state law. Tribes can use written marriage law or code or ordinance or tribal custom. So what about non-Indians? Again, like I didn't answer it. This is a question. What about non-Indians? Can they consent? It's civil. Can't non-Indians consent to tribal court jurisdiction if it's a civil matter? I think they can. Divorce. Tribes can dissolve marriages and domestic partnerships. This is concurrent with the states as well. So what does that mean? It doesn't have to be a marriage under tribal law. So there's a misconception. Only tribal courts can only dissolve tribal court marriages. Nope. No. Again, what about non-Indians? Because if you do this in your tribal court, you're going to see couples who maybe one is a member, one is not a member. And maybe just your court does divorce so well, you've got non-Indians flooding your doors. That has not happened to me, but potentially. So it's just something to consider. Child custody and support, kind of the same as the marriage and the dissolution. It's concurrent between tribes and states. Custody disputes between parents are not covered by ICWA. It is not an ICWA case if it's a dispute between parents. Tribes and tribal businesses cannot be compelled to garnish wages pursuant to, again, I can't see my slide, to state child support orders. So that might be an area you want to develop. If you want to enforce those orders, you need your own law to do that, or policy. Income from tribes and tribal businesses is allowed to be considered for calculating support amounts. Tribal court can recognize and enforce orders from other courts and I recommend seeking tribal court recognition of state court order for, or an MOU with the tribe for enforcement of support orders. So again, this is another area just right for tribal court jurisdiction and also for maybe some collaboration with your state court partners. They have a lot of tools to collect child support that you may not. Adoption, same, concurrent. You can use written laws, codes, ordinances, or custom. And there is an actual state court law or state law in California, the Tribal Customary Adoption Act, that recognizes customary adoptions for tribes. And there's a whole process. And we just won't get into it today because we don't have time. But the point is, this is an area for tribes to go into. They're interested in exercising jurisdiction. Okay, domestic violence. You don't have to be exercising the special jurisdiction to be to have a domestic violence docket, caseload, and laws. So first, there's the area of protection. Tribal court protection orders are an option. You can participate in Project Passport, although I never hear much about that anymore. I don't know if that's still going. State court recognition, that varies again from state to state, but there's a robust set of laws and policies in California around state courts recognizing tribal court protection orders. And then we did talk briefly about the special domestic violence criminal jurisdiction. The takeaway here is this one is one where there is actual federal law that recognizes that state courts must recognize and enforce tribal court protection orders. In practice, I think we're still working on getting that perfected, but what it means is you can set up a system where your tribal members can come to your tribal court seeking protection when they are in a family violence situation. So this is, again, think of that wave. This is really a powerful force to let people know that your tribe has a stance on family violence and what that is and what protections you're going to offer. Prevention. You can also offer things like batterers intervention programs, victim impact circles, and cultural sentencing. So going back to thinking about law as a social construct, sending a message about your community. These different programs here say something. When I'm thinking about the Wilton Tribal Court, where I am the chief judge, we're working on developing programs around family violence, safety, protection, and healing. Those are our messages we're trying to send. And we're very thoughtful about the laws we consider and the programs that we fund. Housing and lands, our homes, our community. So thinking about housing, you can have jurisdiction in your tribal courts over housing lease agreements, over land assignments, which is quite a big deal, also over evictions. Some of these things, if you don't exercise this jurisdiction, nobody's going to. So that's another thing to think about is where are the gaps? Where do you find your community members are coming to your government, to your social services departments, to your education departments asking for help and wondering where are the state resources? And if there's a gap there, can you fill it at your tribe? And does the justice system have a role? Land use. Tribes can decide what is allowed in the community and what is not and where. And what are the consequences of violating the laws or policies around that? So how is your land to be used? Do you have areas of your land you control that are sacred and should only be used by certain people at certain times? Do you have certain areas that you want to be designated only for one? Oh, am I back? Okay, I'm back for me. I hope I'm back for everyone.
You froze. If you could back up for a couple of minutes.
Sure. How far back? Did I get to land use?
We're just beginning that.
Okay, great. So land use. Basically, tribes can decide how to use the land, what's allowed in the community and where. Think about, is there an area of land that you want to only be used by certain people for certain things? Is there a sacred area that should only be used during certain times of the day or times of the year? So those are things that tribes do have authority to legislate and then enforce in their tribal courts. Again, oh no, there I'm back. Okay, this is one of my favorite areas. So I like to call these the big E's: enrollment and elections. And anyone who served as a tribal court judge knows these cases are not easy. But I didn't say this was going to be easy. I don't care about easy. Do the work. These are great areas for tribes to exercise their sovereignty, to grow their jurisdiction. And no one else has jurisdiction over these areas unless the tribe grants it to them. So in California, yes, a lot of our constitutions that were really boilerplate constitutions put in place by the Bureau of Indian Affairs of Indian Affairs. Well, most tribes at this point have removed that.
Christine,
So,
we lost
yes.
you. We lost you again for about a minute.
Oh, darn. Okay. So sorry. I don't know what's happening, but because I actually don't have all of my entire family here today, but okay. So we'll go back: enrollment, elections, and I don't know how far
You were
heard.
telling us it wasn't easy.
It's not easy.
That you signed up for easy and it didn't work out that way.
I actually was never deluded. But anyway, these are important areas because no one else has jurisdiction over these areas. And I think that, why is my internet connection unstable? I think that for tribes to exercise these means a lot, and it's a great way to grow your sovereignty and to also affirm your jurisdiction in your tribal court. So these matters, I was saying elections, I don't know if I got this far, but it used to be in all of our constitutions in California, or at least in a lot of them, they were boilerplate, they were from the BIA, and our elections did have to get confirmed by the Bureau of Indian Affairs afterwards. But most of the tribes I work with have taken that out of their constitutional language at this point. And so think about having these disputes go into your tribal court. It saves the tribal council or tribal board of directors of or the executive council or the business council from constantly having to deal with these matters. And it also creates additional levels of review for tribal members to go through. And I will say, again, just having been a Native person in California for years and years, I've watched many disputes in both of these areas and seen tribal people reaching out for help outward, and it just wasn't there. And sometimes the help that came did more harm than good. So I would encourage tribes, look at these internal tribal matters. And there's others. These are just the ones I call the big A's and focus on. And I've had to hear both, and I'm still here. I survived, the tribe survived, and we all made it through, and it was worth it. Okay, natural and cultural resources. Is my Judge Thorne, am I still alive?
Yes.
Okay, good. Just again, try to ping me again if it goes down. So this is an area.
Looks like we have lost Christine. We'll try and get her back shortly. I will also get a copy of her PowerPoint, and I'll ask John Miller to send that out to everybody who has signed up today so that you get a chance to look at that again later as well. And there was a question in the chat box about will we get access to the slides and the recording? John Miller will be working on making the complete series available. It may take a period of time to do that, but the intention of UC Davis is to make all of these recordings available online so that you can stream either the ones that you missed or the ones that you would like to review again.
Okay, that was strange. Hi, everyone.
Thank you for coming back. I was ad-libbing. So
Oh, good. Well, you can handle, just take over. My internet doesn't want me talking to you today. Let me share my screen again, and I'm almost done. All right. Okay, cultural resources. So sorry for the interruption, everyone. Well, this is just sort of life after COVID. But what I was saying, I was giving a shout out to the Yurok tribe because they've done some really exciting things around protection of natural resources and cultural resources, which in our culture, we sort of blend together. I dare say there's not a natural resource we don't consider a cultural resource as well. And doing things like actually giving rights to our rivers because they provide life and are their own entity. So reconceptualizing what are natural resources, what are cultural resources. And, you know, people ask me, well, how do you enforce that? Is it enforceable? Well, we won't know if we don't try. And so, again, being somewhat complimentary of oneself to complement one's tribe. But the Yurok tribe's really done a lot of impressive things here. And I think a lot of it is just having the confidence to go forward and try. So I encourage everyone, if you've got cultural resources that are important to you, partner with your tribal court and create some enforcement actions and see how far can you go. Okay, this is my closing message, and thank goodness, because Zoom hates me today. But this is a quote at the beginning of something that a very close friend of mine said to me. And we lost this person this year to COVID, and she was a tribal court judge as well. And we used to talk ad nauseum about these issues of tribal courts and how to improve them and jurisdiction and sovereignty. And we were talking one time about a community I was working for. And I was saying, you know, we don't know all of the customs and traditions. And people always say incorporate culture into your court. how do we do that when so many of our customs are dormant through our past traumas that we experienced at the hands of outsiders? And she said to me, we're all working to repatriate our customs and traditions. And that's something I'll get to take with me long after she's crossed. So basically what I would say is use your tribal cords to repatriate your culture, awaken what sleeps and what's dormant. Pass legislation that means something to your community and then enforce it in your court or your justice forum. It can look any way you want. That's sovereignty. It's not that we should give up our fight for justice in the US courts. I'm not saying that, but we must also focus inward and develop our own responses to justice needs. So, Wopla, thank you all, and I'm ready for questions.